They sued us for asking for public records, how Santa Cruz County, Arizona turned a public records request into a legal weapon, raising grave First Amendment concerns. Press release, by John R. Brakey, Ken Bennett, and Bill Reisner. Tucson, Arizona, April 18, 2025. In a move widely condemned by transparency advocates as both unprecedented and unconstitutional, Santa Cruz County, Arizona, has filed a lawsuit against the nonprofit election oversight group AUDIT USA and its director, John R. Brakey, for the act of requesting public records the county had previously committed to release. The lawsuit, filed on August 18, 2022, just hours before the county's written deadline to deliver the requested documents, targets Brakey's lawful request for cast vote records, CVRs, digital summaries of how anonymous ballots are counted. These records are a critical component of election transparency and have previously been disclosed by the county without issue. This case isn't just absurd, it's dangerous, said Brakey. If governments can sue citizens just for asking questions, then transparency is dead. And if a nonprofit like ours can be dragged into court for doing our job, any Arizona citizen could be next. The strange story began on July 28, 2022, when John Brakey requested public election records from Santa Cruz Election Department for the August 2, 2022, primary election. The Elections Department's attorney initially emailed Mr. Brakey on August 11 to let Brakey know that it would be providing the requested records by 5 p.m. on August 18. Then, without any communication or warning, the county sued Mr. Brakey and AUDIT Elections USA on August 18, 2022, the same day they had promised to provide the records. AUDIT's legal team has filed a cross-appeal with the Arizona Court of Appeals, asserting that the lawsuit was not justiciable, meaning there was no actual legal dispute at the time of filing, and not justiciable because the county had no right to sue a member of the public simply for requesting an elections record. AUDIT USA is seeking a remand for a hearing under ARS Section 12-349, which mandates the court to award attorney fees and possible sanctions against parties who bring unjustified lawsuits. This case is a direct threat to democracy, said Ken Bennett, chair of AUDIT USA. If governments can hire private attorneys to weaponize the courts against citizens who ask legitimate questions, then our constitutional right to ask for governmental records is in peril, and seeking transparency becomes a liability rather than a right. Key facts. August 11, 2022, Santa Cruz County promised in writing to provide the CVRs by August 18. August 18, 2022, instead of releasing the records, the county filed a lawsuit, without any communication, denial, or explanation, on the same day they had promised to provide the records. Arizona public records law does not allow government agencies to sue requesters, it only allows requesters to sue if their request is denied. In 2020, 2 years earlier, CVRs were provided by Santa Cruz County to another requester without legal objection. Rather than seek guidance from the Arizona Attorney General or Secretary of State, the county opted for costly litigation, billing around $100,000 in taxpayer-funded legal fees, and is seeking to recover those costs from Brakey and AUDIT USA. County government should consider the implications of hiring private attorneys who may prioritize their own financial interests over effective governance. This is just one more reason that our country is turning cynical against this kind of democracy. The government should avoid hiring private attorneys who prioritize profits over good governance. During our last court appearance, AUDIT USA's attorney, Bill Reisner, raised questions about the charges, which led to a denial and a subsequent change in billing practices. Here is a link to the billing from August 2, 2022, to July 30, 2024. After billing $97,896.80 in the first 2 years of this litigation, the private Pearson Coleman firm representing Santa Cruz County shows only one invoice for $525 since August 1, 2024, for a new total of $98,431 through March 31, 2025. Despite having done extensive work on this case during those 8 months, apparently in an attempt to show the judge that AUDIT USA should receive minimal compensation in attorney fees. County government should consider the implications of hiring private attorneys who may prioritize their own financial interests over effective governance. This is just one more reason that our country is turning cynical against this kind of democracy. It's easy to become cynical when a court officer misleads the judge again, this time regarding his billing, suggesting Mr. Reisner was wrong about PNC invoices. I can provide them with Excel format upon request. The actual amount was not $70,000 as previously mentioned, turned out to be $90,682 as of PNC last billing on April 15, 2024. Refer to the chart for details. April 15, 2024, court hearing. Excerpt from the bottom of page 17. Bill said, and it was something like $70,000 as of the time that Santa Cruz had spent on attorney fees. We never threatened to sue them. We wouldn't sue them. And they picked us because it's something they want to know the answer for? The attorney in this case that filed it, Christina, she's on the state board and advises the governor. Who else is on this board but Fontes? Maybe they could ask Fontes. He supports the bill that we got through the legislature that says ballot images would be made public. And it passed and went to the governor, and she had some objections. On the bottom of page 37, attorney for the plaintiff Pierce replies to the statement about monies built. Pierce said, I did not want to mention some things were brought out there, something about $70,000 in attorney fees. That certainly has not been our firm. So I don't know where that came from. We're nowhere even remotely close to something like that. So I want to make sure the record was clear. We have not been paid that kind of money for this, even remotely close. Bill and I had underestimated, it was not $70,000, it turned out to be $90,683 as of April 15, 2024 billed. Again, refer to the chart above for details. This lawsuit is not only baseless, it's punitive, said attorney Bill Reisner. It violates both the spirit of transparency and the letter of the law. This is about protecting every Arizonan's right to ask questions without fear of retaliation. AUDIT USA urges the public, press, and elected officials to take notice and stand up for open government and our First Amendment protections. Press freedom organizations have termed lawsuits of this nature against AUDIT and Breaky as SLAPS, which stands for Strategic Litigation Against Public Participation. This describes the practice of using legal action as a means to silence individuals, including journalists and other public figures. Members of the public in Santa Cruz, former officials and candidates asked to help once again expose. Such litigation is intended to suppress free speech and participation, and it is too often effective in achieving that aim. Furthermore, all of the counties in the state of Arizona are refusing to provide the CVR database until this is resolved, said Bill Reisner. In any healthy democracy, transparency is the currency of trust. Without that trust, our democracy is dying in darkness. End of press release. 30. Santa Cruz County initially promised to provide the election CVR database but sued us for requesting it. Discover how a corrupt county challenges an experienced attorney of 57 years and a watchdog transparency group who specialize in elections. By Bill Reisner and John Breaky. On August 11, 2022, Santa Cruz County Elections Director Alma Schultz confirmed through her attorney that they would provide cast vote record (CVR) database to AUDIT USA by August 18 by 5 p.m. These digital summaries, if you can get the ballot images, also can be hyperlinked into the CVR and be used to verify election results in a Microsoft Excel spreadsheet. Then, just hours before that deadline, Santa Cruz County filed a surprise lawsuit against me and AUDIT USA. Let that sink in. We were sued merely for requesting public records, the same records the county had previously pledged to provide and has provided in the past. I have been obtaining election databases in Arizona since 2008, following a successful lawsuit in Pima County that mandated their release. In 2020, Maricopa County elections provide us through a public records request the CVR database of over 2.1 million anonymous in a spreadsheet format. This is the same thing that we've asked from Santa Cruz County. Because of that lawsuit, Maricopa is no longer releasing this record until this lawsuit is resolved. Exact quote from their letter of August 11, 2022 stated, for items 2 to 6, we have identified these records requested and determined the time allotted to produce the records, which will be transmitted to you by 5 p.m. on August 18, 2022 via a file share link provided by the county. In a court filing, Pierce and Coleman Law Firm wrote to the court and said this. On August 11, 2002, the county wrote to defendant that the ballot images were not subject to disclosure due to statutory protection under ARS 16-625, but but the remaining records were likely to be ready for disclosure during the week of August 15, 2022, and would be transmitted electronically following the completion of statutory election duties, including the election canvass. That statement is false. Starting after the but. Note, likely to be ready for disclosure during the week of August 15, 2022. That's not what their letter of August 11 stated. A lawsuit with no dispute. As our legal counsel Bill Reisner writes in his reply brief to the Arizona Court of Appeals, no dispute existed when the county sued Audit and John Brakey. In fact, the last communication between the parties was one of agreement, not adversity. Yet the county claimed they had a good faith dispute and needed judicial intervention. According to Arizona law, that claim is not enough. Citing the 1965 precedent Manning v. Riley, Reisner explains, to serve as a basis for declaratory relief, there must be specific adverse claims based on present rather than speculative facts. To state it concisely, one cannot initiate a lawsuit merely based on potential future intentions. Nevertheless, that is precisely what Santa Cruz County did. They launched a preemptive legal action not to clarify the law, but apparently to penalize a legitimate public records request. This case isn't just absurd, it's dangerous. In the words of our chairman and former Arizona Secretary of State Ken Bennett, if governments can hire private attorneys to weaponize the courts against citizens who ask legitimate questions, then transparency becomes a liability rather than precious right. And that weaponization came with a steep price, taxpayer-funded legal fees that now top 6 figures. And they will have to pay our attorney in the high 5 figures. Reisner notes that the county could have avoided this entire legal fiasco by seeking guidance from the Arizona Attorney General or Secretary of State, both of whom offer free legal opinions to counties. But instead, Santa Cruz chose the most expensive and aggressive path available, private litigation. Neither the Office of the Attorney General nor the Secretary of State would have cost the county any money for their opinions, Reisner writes. Instead, they chose to pay their counsel many tens of thousands of dollars and to request AUDIT USA and John Brakey to pay their fees. Who ordered this? Another unresolved question looms large: who made the decision to sue? Reisner makes it clear that AUDIT USA is not trying to crusade against the county or its attorneys. Rather, we are seeking a hearing under Arizona Revised Statutes sections 12 through 349 and 12 to 350 determination of award, reasons, factors, a process that allows the court to determine whether attorney fees and sanctions should be imposed for bringing a lawsuit without substantial justification. That hearing, known as a culprit hearing, would determine whether the fault lies with the county, its attorneys, or both. Defendants do not know what advice was given to the county nor why the Board of Supervisors and county election director might have wanted to keep all election data secret from the public, Reisner states. But what we do know is damning. Evidence of secret planning. County billing records, obtained as part of the case, show that legal invoices titled Santa Cruz Elections Lawsuit, Billable, began on August 1, 2022, 10 days before the county promised to release the records and 17 days before the surprise lawsuit was filed. There were no communications from the county to AUDIT between August 11 and August 18, the brief notes. So, while we were preparing to receive the promised public records, the county was secretly preparing to sue us. A manufactured crisis. Santa Cruz's central claim is that a 2017 law ARS Section 16-625 suddenly barred them from releasing CVRs. But the county had previously released these exact records in 2020 with no issue. For 5 years after the law passed, no Arizona county interpreted Section 16-625 as applying to CVRs. The county never sought legal clarification, only court-imposed retaliation. Their expressed reason is because a court opinion would be quicker, Reisner writes, but that is clearly not true. As far as we know, they still haven't asked for an attorney's general opinion, and it's now 2025. Instead, they pursued a strategy of legal intimidation, what press freedom advocates call a slap suit, strategic litigation against public participation. Legal gaslighting. In their filing, Santa Cruz County referred to AUDIT USA's defense as something that can't be serious. They called our effort a crusade. But it's hard to take that language seriously when the county is the one that filed an unprovoked lawsuit after promising cooperation. And it's not just about this case. The county's interpretation has had a chilling effect across Arizona. Since the lawsuit was filed, no county in the state has released CVRs. If they win, it sets a precedent. Governments can sue citizens for requesting public records that they've released before, without any denial or warning. The real threat to democracy. This isn't just about one activist or one county. It's about whether public officials can use the courts to silence transparency advocates. Whether they can redefine laws retroactively to cover their tracks. Whether they can shift the cost of their secrecy onto the very people asking for openness. As Reisner concludes in the final paragraph of the brief, this case concerns their decision to sue AUDIT USA and John Brakey. It does not relate to the merits of whether or not ARS Section 16-625 prevents disclosure of CVRs. This cross-appeal concerns Santa Cruz County's decision to sue a clear violation of the important protections in ARS Section 12-349. We are asking the Arizona Court of Appeals to do what the county would not: follow the law. And send a clear message that transparency is not a crime. In Arizona, a culprit hearing is a type of court proceeding used to determine who is responsible for misconduct in a legal case, the attorney or the client. It typically arises when sanctions, including attorney fees, are being considered under ARS Section 12-349, which allows the court to penalize a party or attorney for bringing or defending a claim without substantial justification, or for unreasonably delaying or expanding litigation. Why it's called a culprit hearing. The term culprit hearing isn't formally used in statutes but is commonly recognized in Arizona case law. It comes from the need to determine fault when sanctions are on the table. The court must decide. Was it the attorney's fault for bad legal advice or tactics? Was it the Board of Supervisors' decision to pursue or defend the claim? Or were both responsible? Arizona case law examples. Small Blue Diamond Marquez vs. Ortega, 231 Arizona. A culprit hearing is aimed at protecting a party from dispositive sanctions when the fault lies only with counsel. Small Blue Diamond Lund vs. Donahoe, 227 Arizona. Reinforces that courts must distinguish between attorney and client conduct when imposing sanctions. When is a culprit hearing required? A court must hold a culprit hearing before allocating responsibility for attorney's fees, sanctions, damages under ARS Section 12-349 and Section 12-350. Especially when the court is considering punishing only one party, and there's ambiguity over who made the decisions in question. In our case, AUDIT USA v. Santa Cruz County. Attorney Bill Reisner is asking for a culprit hearing to determine if the county's Board of Supervisors initiated the unjustified lawsuit, or if it was a decision made by the private attorneys hired by the county. This is critical because it would determine who pays any court-ordered attorney fees or sanctions. Links to downloadable file that will have these records. File folder with 6 press release with update and links since the case started August 18, 2022, to April 14, 2025. File folder with 3 briefs that the court is relying on to decide the case. Check back. Video link to Ken Bennett's 5 recommendations for restoring confidence in elections and combating the cynicism that is undermining our country. Link to watch Ken's 5 points, show how ballot images and CVR are audited in Microsoft Excel using ABE. Subject: Sunshine Week, public records, and the urgent need for accountability in Santa Cruz County and elections nationally. As Sunshine Week approaches, a time nationally recognized for promoting government transparency and the public's right to access records, I feel it's critical to shine a light on the troubling situation unfolding in Santa Cruz County, Arizona. Given the harassment I've experienced simply for exercising my legal right to request public records, I'm asking for guidance on which national organizations or watchdog groups I should contact to help expose what may be one of the most corrupt county governments in the United States. Santa Cruz County's troubling track record includes the case of former County Treasurer Guthofer, who embezzled $39 million over a decade, continues to raise eyebrows due to its scope, duration, and unresolved questions. The former county assessor was arrested and charged by the FBI for accepting bribes. There is an ongoing scandal within the county attorney's office involving unaccounted funds, adding to a history of troubling misconduct. Before legal action was initiated by Santa Cruz County, I was investigating the county recorder's vote-by-mail procedures. My findings revealed significant gaps in oversight and safeguards, presenting conditions that could potentially be misused. These are not isolated incidents, they are symptoms of a deeper culture of secrecy and abuse of power in Santa Cruz County, AZ. In late July and early August 2022, I uncovered what I believe was a vote-by-mail manipulation scheme orchestrated by the county recorder. She had complete control over the process and took deliberate steps to block oversight. After I began to investigate, she made false accusations against me but then refused to testify in court, likely because she knew those accusations wouldn't hold up under scrutiny. She won her last election by a razor-thin margin, just 91 votes in 2020, if I recall correctly. Rather than face questioning under oath, she chose to resign. Ironically, the person who may have been the true winner of that race ultimately became the recorder. Read my article, What's the difference between a logic and accuracy test and an emissions test? Not much. Understanding the role of logic and accuracy testing in electoral process, what it is and what it is not. My next article, Techno-feudalism, are we living under its rule? Has big tech become the new monarchs, and what does that mean for elections, democracy, and our democratic republic? Santa Cruz wasn't the first big case of embezzlement by a treasurer of a municipality or county. All the Queen's Horses embezzling $53 million, true crime, full documentary 352,000 views, May 19, 2022. How could one woman steal $53 million without anyone noticing? All the Queen's Horses tells the story of Rita Crundwell, the perpetrator of the largest case of municipal fraud in American history. The Rita Crundwell embezzlement case. Rita Crundwell served as Dixon's comptroller and treasurer from 1983 until her arrest in 2012. Over a span of 22 years, she embezzled approximately $53.7 million from the city, a staggering amount for a town of about 15,000 residents. Crundwell funneled the stolen funds into a secret bank account and used the money to finance a lavish lifestyle, including the development of a nationally recognized quarter-horse breeding operation. Her fraudulent activities came to light when a city clerk discovered the unauthorized account while Crundwell was on vacation. Subsequent investigations by the FBI led to her arrest in April 2012. In 2013, she pleaded guilty to wire fraud and was sentenced to 19 years and 7 months in federal prison. At AUDIT USA, we will continue updating this Substack page with new information, documents, and links as the case develops. We believe this is a critical moment to raise public awareness, especially as we move closer to the 2026 midterms. Our democracy is already in crisis. The only reason violence didn't erupt after the last election is because MAGA-aligned candidates won key races. But the next election may be different. Holding control of both the House and Senate will be far more difficult. And if they lose, we face two dangerous possibilities: they could falsely claim the election was stolen, or worse, manipulate the process from within. Wake Up Tucson Show, Santa Cruz sued AUDIT USA and John Brakey for filing public records request and lost badly. December 19, 2022. Transparency on trial, why is Santa Cruz still fighting? At first, it was hard to believe, but yes, Santa Cruz County appealed. Their decision to continue this legal battle has triggered a chilling effect across Arizona. No county is currently releasing cast vote records, CVRs, while this case remains unresolved. That's a serious blow to transparency and to public confidence in our elections. One has to ask, how many other counties are represented by the law firm Pierce & Coleman? Something doesn't smell right. In today's world, with ballot images and cast vote records readily available from digital voting systems, there is no excuse for any voter to walk away from a polling place and wonder, was my vote counted as cast? Verification is not only possible, it's simple. Unless you're fighting transparency. So we must ask, are they really protecting election integrity? Or protecting their ability to manipulate the outcome? For the last two statewide general elections, voting has been restricted for the 2022 and 2024 general elections. We have returned to faith-based voting practices. And now, unbelievably, they're pushing a legal theory that all electronic voting records are exempt from public records law. Let's be clear, that's complete nonsense. Just look at ARS Section 16 to 625, it was never intended to shield election records from the public. Now they're not just claiming CVRs are off limits, they're arguing any digital record is exempt. Think about what that means: ballot images, cast vote logs, scanner logs, system files, all locked away from public view. And remember, we never get to see the original paper ballots either. So, what are we left with? A system of total concealment? A pattern of secrecy and avoidance. After the November election, I submitted public records requests to 5 Arizona counties concerning the Congressional District 6 race. I won't go into details here, but I monitored that election closely and have serious concerns, particularly regarding Cochise County. This isn't the first time Cochise has raised red flags. Back in 2014, Attorney Bill Reisner and I filed a lawsuit stemming from issues in that same jurisdiction. And now, more than a decade later, Cochise is once again at the center of an elections controversy. I'm the first to admit, maybe nothing went wrong. But in a functioning democracy, should we really have to wonder? Shouldn't we be able to verify that the vote was legitimate, independently and publicly? A better way forward exists. Why is it not feasible for counties to run a program like ABE on an independent, offline computer that is never connected to the election management system, EMS? This simple tool can sort all digital ballot images by precinct, hyperlink each image to its corresponding record in the Cast Vote Record, CVR, database, upload the linked images to the cloud for public viewing. Therefore, it would be beneficial to distribute precinct-level CVRs and associated images to every precinct committee member and offer a brief training session. Within an hour or two, they could audit their own precinct, confirm that ballot images match the CVR data, restore confidence in our elections, one precinct at a time. They say you can't have both speed and accuracy in elections. With ABE, you can. The persistent use of black box concept with digital voting systems is crazy. Why are counties still refusing to use existing digital tools that would allow voters to verify election results and restore trust in the process? We have the means. Tools like ABE, auditable ballot examination, can run independently on an offline computer, completely isolated from the election management system, EMS, yet provide full transparency by linking public ballot images to cast vote records. Instead, most jurisdictions continue running black box elections where voters insert ballots and are expected to blindly trust the outcome without ever seeing what happens in between. That's not democracy. That's not transparency. And that's exactly why millions of Americans have lost faith in the system, believing elections only change things when a billionaire with an agenda pulls the strings. We can do better. We must do better. That's why many electors/voters in our country have lost faith in democracy, believing elections only bring change when led by a billionaire aiming for oligarchy. John R. Brakey, Director, Audit USA. Email johnbrakey@gmail.com. Americans United for Democracy, Integrity, and Transparency, Arizona. Thanks for reading John's Substack. Please subscribe for free to receive new posts. Audit Election USA's work. Please share with others and keep informed. Audit USA is a 501(c)(3) organization. Your donations are tax deductible. Mail a donation to Audit USA P.O. Box 26361, Tucson, Arizona 85726. Or donate online using this line or the QR code. We appreciate donations of any size.